So I'm just reading the judgment J Cats.
Yes, Cats J, yep. That is the one, that is the powerful one in regards to Habeus Corpus. That is the one that I drew up in for the person that's down in Christchurch prison as well, and put that one in there because the fact that a chief executive of a government department, one of the lawyers, accepted that the guardianship order constituted detainment for the purposes of Habeus Corpus, simply means that a writ had to be issued. And as they said, if you're looking at paragraph 27, it's only because the baby was not in New Zealand that the writ didn't get issued. However, if the child was to come into New Zealand from Guam, the chief executive was to apply for the custody and guardianship. The minute the guardianship was obtained, that is enough to issue the writ.
Yeah. The Court of Appeal has observed.
That's a pretty powerful bit of case law there.
Right. Wow. Just reading through it now. So do you want to just go through all of those ones you sent me, or is that just so I
just
have it for a
go
reference?
through them one bit by bit and just have a read. Gives people the ability to have an understanding of what they can and can't do, because it's not just in regards to Habeus Corpus. There's one case in the, I think it's GNS or something like that. I've been reading so much I forget what it is now. But there's one case law in there where, like if someone's going for a, the court tries to order a 133 report under subsection 6, section 7 I think it is, there's not the ability to do that without getting the child's views on it first. Which sort of nullifies the getting the 133, because if you're trying to work out what you're going to do regarding a child, what the lawyers say in the judgments is, what is the point of assessing the child's views on having the 133 when it's in regards to dealing with the child's welfare that the 133 report is required. But a lot of people out there won't know that if you're dealing with Care of Children Act and they're trying to make changes within parenting orders, like varying the parenting orders, a requirement of that is that the court must get a section 133 report and have a safety hearing to assess what the psychologist says, if any, could be issues. Without doing so, that becomes an error in judgment, and so you can turn around and appeal it or judicial review it.
Is that number 2 are we talking about link number 2 here you're talking about, or the S&L?
I'll just go into my email so that I can see what's going to be.
Because we just looked at the S&L family court one, which was the guardianship constituting detention. So now are we talking about number 2 there, or? I'm
just going to go into
and for some reason your camera's dropped out, bro. I can't see you. All I'm seeing is a big round BA.
Hold on. I'll turn it off. Oh, there we go. Don't know how that happened.
Just the last couple of minutes, it just went blanked out, but that's all right.
Yeah, it probably just went, hey, Durbrain, you're not paying attention. Okay, so this is going to be really bad because it means that you can tell I've read it. O'Connor versus as litigation guardian. There's a case in regards to a 16-year-old boy that was put into a secure facility. The issue for the chief executive was that if placing a child into a secure facility requires a section 364 or 365 order, because that's the only ones for a secure facility. This boy was under S101, so they didn't have the facility to hold the correct order to hold him in a secure facility. What this means is that any child under a 101, it doesn't actually have to be a secure facility. So if a child's placed under an S101 and placed with a caregiver, for instance, that caregiver's house, if the child can't leave it on their own without getting consent, they are at a restricted location. So therefore, if you've got a restricted location, you've got detention, and you can, like that lawyer did, apply for habeas corpus to have him released from it, because that case was taken by the lawyer for child.
Yeah.
So what it means is, where parents are led to believe under the OT Act that you can either Section 125 apply for a discharge or variation of the orders, or Family Court Rules 2002 Rule 34C, you can apply to rescind the orders. What it's meaning is that in doing the research on the judgments and that, finding other ways where like on 125, if you've had a final parenting order go in place for OT, for instance, under 101, you don't have the ability to apply to discharge it again. Once, like if you make one discharge application and you fail, you can't apply to discharge again under 125 for a period of 2 years, because you're subject to 206A leave. You've got to apply for leave of the court, which is what we've had to do at the moment. But the issue for this kind of thing is you can also apply to the High Court to declare the orders unlawful if you have enough proof in regards to it, or you can apply for habeas corpus and have them released from detention. So it's other avenues that lawyers don't tell you about that can get your child, like habeas corpus, if you're successful, from the time you apply to the time it's supposed to be heard in the High Court is 3 days. Whereas you've got parents out there that are waiting for hearings that are taking months and months and months. But the other discovery I've made is that if you go to a directions conference and they say, right, the next one we're going to is the hearing, they are required under the Family Court Rules, Rule, what was it, 146, I think it is. I'll just double check that actually. But there's a Family Court rule that they have to do the hearing with directions conference. So when everybody's having all of their is drawn out, they don't actually have the ability to do so. They must hear it within that time frame. And so that's why these ones are going on for months and months and months. Was it 146 or 246? I'm just waiting for this to load. Like I say, I've been through so many numbers, it takes a little while for them to register in the brain.
That's all right. What rule did you reckon it was? 140?
I think it's 146 or 246. It's got a Z after it. So, 4 something. 416, I think it is. Now that I think about it, it'll be 416Z. Directions conference. Right?
Yep.
And it tells you that once you go from the 416Z, 4, is it 4? Yeah, there's a rule here, number 5. If the proceedings are on foot, have been made on without notice, and this is why I always say to people, if you're going to make your application, don't do it on notice, do it without notice, so that if the judge puts it on notice, you're still on the without notice track. Number 5 says, if the proceedings are on the without notice track, the period between the directions conference and the subsequent hearing must, where reasonably practicable, be not more than 3 weeks. That's why you have the 14 days to put your affidavit in, and then they respond and get 7 days to respond, because there's your 21 days. We're now at a hearing, so it's all heard. But that is not occurring in New Zealand.
Because the family court, or who's not following the rules?
It's because, well, all I can put it down to is if you've got counsel, like a lawyer, then your lawyer is not making sure your case progresses in a timely manner, which they're required to do. If it's a self-representative, it's simply because the self-representative doesn't know, but then it's in the family court rules as well that if you're a self-representative, the court must make sure you're aware of your rights. They never do that.
Yeah.
They never do that.
So can you see the family court rules there?
Yep, I can see the family court rules, and the rule that I'm talking about is right down the bottom of subsection 5. So
this bit right here.
Yep.
Yep.
Quite clearly says you're wherever practically possible within 3 weeks. So a 21-day period, which now when you think about it, like I said, makes sense, because normally, like sometimes they'll do a reduced time frame. You might get 7 and 7, which is, you get 7 days to put your stuff in, they get 7 days to put a response in, and then it goes to a hearing. But it quite clearly tells you that any family court matter is supposed to be heard in that time frame from a directions conference. I mean, we've had directions conferences and then had to wait, 3 months for the hearing. In fact, the first hearing we had, from the directions conference to the time of the hearing was 21 months.
Jesus
That just
Christ.
goes to show you how far out some judges don't care.
Well, here's an interesting one for you, bro. I rung up the court today to find out about my defended hearing for the ticket that I got back in back in April, and she was a lovely girl, Ellie, very friendly. Gave me all the information I need. Took the joke on the thing about, well, I don't know my date of birth, but Mum does. You know, they always get a bit of a chuckle out of that one. And then I said to her, I says, can you tell me what's happening? And she goes, yeah, it's scheduled for a judge alone trial, 27th of January next year. And she just had to let me know that if I don't attend, the hearing will go on. I says, it's all right, I understand all of that. I said, is there some way that you guys can you can get the district court to send me a copy of the defended hearing, you know, a notice of proceedings for the defended hearing, just so I know a fixture date? No, we don't do that. I have to email the district court directly and ask for them to give me a written form to say when my next hearing is. If not, she's set it up so I get a little text reminder on my phone now. How helpful. So, but they couldn't send me an email or anything to confirm it, so I just thought that, so if I hadn't have run, would I have ever been known or told?
Yeah.
You know, but
you know, it's been an interesting read over the last few weeks. Like number 3, Kneecal versus Nikia.
Yeah.
That's that judgment.
I'll pull these up so we can have a look at the same time, eh?
Yep.
Once I find it, I'll just share it across.
Yep.
Come on. Oh, right, okay, so if I share that. Okay. So, Nico versus Nico, this one?
So basically what happened in this case was that you had the mother and father of the child.
Yeah.
The child had gone over to the father's sister and his partner.
Right.
And they had looked after the child for X amount of time. I think it was maybe 2 or 3 years.
Right.
And they were of the opinion that they should have the right to be able to have shared child.
Right.
The issue became, this is a High Court judgment, the issue became that you've got the parents, the natural parents of the child, and then you've got the whāngai parents of the child arguing over the child. And so the whāngai parents believed, because they had the child in their care for a certain amount of time, that they basically had more rights than the actual parents. The issue became this is a care of children case. It got settled by the fact, even though this is a weird thing, you can have secure children cases and OT can be involved in it as well, so that's really weird. That's why I headed at treaty principles, because the treaty principles were under 7AA. They're also under, I think it's...
hang on, am I right in thinking 7AA is the one our dear, sweet, lovely friend Timothy Black went all over the newspapers for? 7AA?
That is correct of the case in the Hutt Village.
Hi, Tim. Yeah.
So basically, the main gist of this case is when you've got 2 different lots of whānau, or if it happens to be a caregiver looking after the child, and then the court decides that the child should go back to the whānau.
Right.
What happened in this case was the justice that did this case looked at all of the avenues that had been done. Okay, and under Section 5 of the Care of Children Act, the whāngai parents were referring to the fact that the relationship between the whānau must be strengthened and preserved.
Right.
What came out of this case was you've got 2 problematic relationships for the child. What they meant by problematic was that the mother of the child wanted to get her child back. The father of the child obviously wanted his child back as well. The whāngai parents wanted to keep the child, However, there was obviously the rift between the two whānaus, between the four whānau members.
Sure.
So what the judge found in the end was, rather than you putting the child through two problematic rift relationships with adults, it was better to have one primary set, mum and dad, take the child back under their care, because there had never been any care and protection concerns. It was a case of the mother had issues with pregnancy in hospital, and so asked the father asked his sister to take the child on board while the mother was recovering. Took quite some time, obviously.
Sure.
But they decided they wanted the child back. But the basic gist of that one is that if you've got a child that's subject to any type of proceedings within the family court, that is good case law for the fact of you can turn around and say, using the sections down to the parts that I've put down further, that's why I've highlighted them bold and italic them, because those are the parts of the things that are best used. So, and there's a lot of different things in there that will suit, parts of it will suit people's cases and parts of it won't. But you see, having some case law is better than having none, as I've discovered. So,
yeah,
like
well,
I say,
we were chatting about that before, weren't we? The doctrine of precedents.
Yeah, doctrine of precedents. So here is a silly thing. The doctrine of precedents, in my view, can be put in the wrong hands.
Oh,
because you can get an abuse case where the child shouldn't go back to that person, and there are case laws out there. I've chosen not to put them in the folder, but there are case laws out there that support people that interfere with children. So that's not case law that should be out there and about. No, I don't know why they have that on a public forum, because it's certainly not in the best interest of any child.
Yeah, exactly. Wow. Mind-blowing.
This is going to surprise you. The Newton versus Family Court, I actually can't remember what that one was about, even though I read it.
Okay, number 4 we're talking about here?
Yeah. So it'll refresh my memory seeing the word part come up.
Okay. I take it you can still see that coming up on your screen there?
I can see it coming up, yep.
Cool. Okay, you've got 2 documents here.
Oh, is that the one that's got quite a few in it?
You've got your Newton Family Court at Auckland doc.
Oh, yes, yeah, that's the one, Newton. No, the second one down. I've obviously put 2 of them in there by accident.
That's right.
Oh, I know why, I'm sorry. I haven't read that one yet. Or have I? Yes, I have. So, what have I put in short difference here? What's it called? That's the 133 report commissioning. So that's the one that deals with subsections 6 and 7. It also tells you, if you look down a little bit further, that when the judges tell us we can't get family court recordings and transcripts, well, it's just up a little bit. There, right there. So that one there, okay, if you can't get the family court to release your hearing transcripts or recordings, if you do a judicial review or an appeal, you request the High Court to get it brought in, because the family court cannot say no to them, but can say no to you.
Yeah, exactly. They can't say no to the higher jurisdiction.
So that's a way where, like, you can say to a judge in a family court, I require it for litigation on my appeal or my judicial review, and they will still turn it down. If that happens, wait till you go to a case management conference and just state, Your Honour, we are going to require the recordings and transcripts from the hearing dated such and such from the family court, and you are making an oral application for the High Court to bring that in.
Yeah, because you don't have to apply in writing. You can make it orally on the day.
Yes, you can make it oral. Yes.
Yep. Cool.
And if you're a lay litigant, they're not going to expect you to know the rule number. So that's the brilliant part about it.
Right, of course.
And now it's got child's views before directing 133. I found it within the judgment where it says, okay, you've got to get the views of the child. This judgment also had Professor Mark Hannigan, who was on the newsroom and was interviewed in regards to when they were doing the uplift of taking the child from behind the couch.
Right.
And as I think he put it perfectly actually when it was in the write-up where he said that we must ascertain the child's view, as the child is the expert in their own life.
Yeah, exactly.
So yeah, I thought he put that brilliantly, because there's a lot of judges, and especially lawyers for children out there, that they say I've got the child's view for the court, but the reality is it is just the lawyer for child's half-assed view of what they reckon the child has said. So I always say like I said to one of the other people we know, in regards to her boys, get them in front of the judge and let them tell the judge himself.
Yeah. So,
Well, when you do that, that can be the best thing sometimes. But if the child has had, how do you put it? If the child has been brainwashed, okay, in that particular manner, then no matter what you do, if they go in front of the judge or with the child, you're going to get the same outcome, because that's all they know.
yeah. And that's why you've got here, family court not to ignore judgment directions of High Court. So.
That's right, because what happened in that judgment was it went back to the family court. The family court chose to ignore what the High Court had said about not doing the 133, and they ordered it again anyway.
Idiots.
So what happened was, this is the first one I know of, but I mean I haven't been doing it for that long. First one I know of where the family court was it was a judicial review. The family court was in there as a party, but what happened was, normally the family court, the lawyer will just say the family court will accept whatever the court's decision is. In this case, the family court wanted to put an affidavit in and be good. So it makes you wonder what they thought they had done wrong in the family court and trying to explain themselves.
Crazy. Right, where else are we up to here, bro? We're up to number 5.
So we're up to M versus M versus Chief Executive. No, not the Nikia one, because we've already done that one.
M versus Chief Executive, number 5.
If I remember rightly, that is our friend. You know the one we were talking about?
Oh, is it? MC.
From memory, MC. I think it's named M by accident.
It's alright, we'll just open it up.
So let's see if I'm right. I'm pretty sure it is that one, but I'm not positive.
It's just the one.
Yes, this is the right. Oh, okay, so no, it's not right. It's not the same one. No, this is the one. So status quo. What the reason I put the status quo in there is because when people say status quo, especially in law, it means the family unit. This is the one where I was telling you about, where it was 2 lawyers fighting for their children.
Oh, the 300 and something plus paragraph decision.
Yes, I think it was 344 paragraphs at the end.
And they were both parents, both lawyers, and they were both arguing it. And the father lawyer ended up bringing in international law and the ICCPR and all of that. Is that the one? Yeah,
the one thing I did disagree with that he did was the family home was in the trust, but he got the trustee changed and then got the trustee to evict and trespass the mother and child. To me, that's not right.
It's a family home, which means the kids, the family, she gets.
But the status quo situation is this: everybody would hear it in the family court. Okay, where the court says, they make an order varying the who's going to have the parenting, the pain changes from one parent to another.
Sure.
Now, the issue is this: we're all led to believe that the status quo is the family unit, but it's not. It can be the family unit, and it could be, like, for instance, a family of 5, 2 adults, 3 children. So your status quo in that circumstance, or even with a mum, dad, and a child, you've got mum, dad, and child. There's your status quo. Right. You've also got mum and child. There's another status quo. Then you've also got dad and child. So there's another status quo. So it's like if you're in a family of 5, and one parent's doing wrong and the other parent's doing right.
Yeah.
The one that's doing right should not be admonished for what the other parent's doing. So that's where the status quo changes, because the parent that's not doing anything wrong, can't have their contact or whatever taken away because of the fact that the other parent has done wrong. So that's where people can turn around and say, well, hold on a minute, I'm being judged on the other parent, and I'm a separate status quo with my children.
Of course.
So like if you've got,
because you've got the whole, you've got the family unit as a whole, but then you've got all the little sub-units inside that family.
Yes, and it also comes down to not just mum and the children. It can then come down to, if say for instance you've got 3 children,
The
it can come
siblings.
down to mum and the three children, dad and the 3 children, or mum and each individual child. So like if one of the children says, I don't want to see mum, okay, that doesn't mean that mum's right to see the other two under the other 2 separate status quos should be removed from it.
Yeah, that just because one child wants to change their status quo doesn't mean it alters the status quo for the other 2 children.
That's right, but when we look at family court cases, that is exactly what happens. The status quo is changed as a generalised situation rather than independent situations that where you're one-on-one.
Right.
But if you raise that up, you can actually get that done because that was done in this case. The father stepped down and turned around and said, well, hold on a minute, my contact with my child should not be subject to the fact that the status quo of the family situation is not going very well because of what his wife was doing.
Yeah.
And the court then accepted that. No, he shouldn't have to worry about that because there is a separate relationship with him and his child.
Which makes absolute sense to me anyway.
Yeah.
Just get
And then you've got the L versus Chief Executive.
too many windows open here, just closing the queue. Right, so, yep, L versus Chief Executive.
I'm just sticking on your ear too, did I?
Yeah, we'll
Got to
go.
be better at that. Yeah, no, it'll just be the L and T.
Oh, Habeus Corpus.
Yes, this is the one where the father changed it, he won it, but the problem was he was in prison.
Okay.
But what it shows, what I wanted to be able to show people with this is, okay, it doesn't matter whether it is an adult or a child, okay, the difference between the two in establishing it is, if an adult brings a case of habeas corpus, it is the body of that has to be brought before the court. If it is a child, it is the mind, soul, and spirit that must be brought before the court.
So
Either way,
how exactly do they do that?
Detention.
So how exactly do they bring the mind, body, and spirit of a child to court?
By stating that the guardianship. So when anyone's given a guardianship order, like people wouldn't believe this, but okay, the minute you go in, it doesn't have to be an OT case. Okay, it can be a care of children case. When you have standard guardianship as parents, that is one thing. Once you go into family court and the court gives even joint guardianship, right? It is very hard to be able to turn around and say. And this is a really, really, really silly way of looking at it, but in law for habeas corpus, this is how it works. If the child is with one parent, okay, under a guardianship order, the child is detained from the other parent due to the guardianship order being in place. Okay? So where they talk about shared care and they do like 3 days on one parent with 4 days on the other one, right? Unless they rotate those weeks, rotate that weekly in between each week. That's they call it. It's not what do you call it? Inequity. You haven't got equal amount of time with the child, and so because of that, if you've got 1 day more than the other parent, you are now detaining the child from the other parent.
Right. So it's
not
equal.
It's an interesting thing.
So it's not
The
equal.
reason I put the section 13 in there, okay, is because section 13(1) establishes a child under the age of 18. Section 2 establishes under 16. They do have the ability to send it back to the family court, but for people that are going through an Oranga Tamariki case, this is the brilliant part. If it gets sent back to the family court and the High Court won't decide on it, when it goes back to the family court, Oranga Tamariki's powers are removed because of habeas corpus can only be heard under the Care of Children Act 2004.
Yeah.
Now, under the Care of Children Act 2004, that removes 101. That removes all of the major orders.
Sure.
And so therefore and they don't have the ability to say to the court, we want it dealt with under the Oranga Tamariki Act, because the Habeus Corpus only deals with Care of Children Act when it comes to children.
So that's like 39, 42, 43, 78, 68, they all disappear.
68, 78, 101, 102, 83, 86.
All of the orders, wow.
Yeah, because what you've got to remember, and this is an important part for people to take note of, Habeus Corpus is not about custody. It's about guardianship and detainment, and the way to establish that that has happened is the guardianship order, section 22 of the New Zealand law in regards to the liberty of a person, not being able to be arbitrarily arrested or detained, the key word being detained, and section 18 of the New Zealand law due to the freedom of movement.
Right.
And when it comes to the child,
which
also is the United Nations Convention of Rights of a Child, Article 3.
And you can use Wright v. Bozale 2016 because he also had section 18 and 22 in his decision.
Yes, and his one was also based on detention as well.
Yeah, that's right. Not being informed of the charge promptly and in full.
Yeah.
Yeah.
Oh, my camera's going for you. What's going on here? There we go.
Just doesn't like me.
That's pretty much that one.
So GS.
G and S. That's the. There's another one with the lawyers involved. That was another 340 odd paragraph judgment.
Gosh, there's a few temps in that folder.
GNS has got a lot in the probably that one there had a lot in it. It's a very useful judgment because this was another lawyer that had let his license expire so that he could take on the family court.
Yeah, because they can't, while they're still under the active license, they can't self-represent, can they? They have to let it lapse. They can self-represent, but they're still stuck within the bounds of the court rules. They still have their duty to, first and foremost, to the court.
Yeah.
Right. High Court to order recordings and transcripts. Ah, yes. Remember that. Family court proceed recordings. Does changing the status quo.
The other thing they don't take into account with the status quo. If the status quo changes, see what the family court does is they'll turn around and they'll change the status quo of the situation, and on the day they'll give a new interim parenting order until such time as the hearing can occur. Now the issue with that is that if it's a care of children case, the 133 report has not been directed. The other interesting thing to know about 133s and 178s is that the court doesn't have the ability to order one unless all parties agree to it being ordered. We have a lot of judges out there that are just ordering the 178 of their own free will, and then they're expecting the parties to come up with the brief for it.
And the child is also a party and must also have an agreement there too.
That's right. The child is also a party, especially. The important thing that I've discovered through reading all these judgments is this: when it's an Oranga Tamariki case, they always refer to section 120 of the Act. No orders can be made for parenting type orders. Section 56, section 48, and section 27(1) cannot be used due to the 120 being in play. Now, the interesting part is we're all led to believe that we were only doing it under the OT Act. That is not correct. The only sections that are not available to us are those listed in section 120. So, a 133 report, the sub-paragraphs or subordinates within the section are available to us to use under the OT Act. So we have the ability under subsection 6 and subsection 7 to go, well, hold on a minute, nobody's ascertained the child's views to see if that child is willing to participate in it. Because in the OT Act, you've got 1781, which is for the child to be done, a child report to be child and the child to be done, 1782, which is for the adult the parent you have be assessed, and 1783. Now 1783, in my view, is a complete waste of fucking time. Because what's the point of saying if that it's got to be consented to? If when the parent says, no, I don't consent to it, then the judges normally go, well, there must be something wrong, and I'm not prepared to do anything to look at giving the child back to you, simply because you did what was in the legislation and was your right to go, I don't want to do it.
Yeah.
So the gist of all of that is refer back to 133 on the Care of Children Act and state to the court that under subsection 6 and subsection 7 has anyone ascertained the child's views on having a report done. Because the child might not want to be questioned by that psychologist. And if that's the case, they have every right not to be. Because that then again would be impeding on section 22 of the Bill of Rights and the UNICROC Article 3 and the ICCPR. Because they have their own liberty and they're not required to do anything that they're asked to do in regards to that sort of thing. In fact, they're not required to do anything that is asked within the Acts.
So what section are we looking at? Care of Children Act or the OT Act?
Care of Children Act 133.
Oh, 133. That's where I'm going wrong. Sorry, my mistake. There we go.
Psychological reports and stuff like that. And if you go down to subsection 6 and 7, there should be subsection 6 and 7 in there.
Yep.
Yep, 6 and 7 don't allow for the court to do it without actually having that child's views. And that's backed up by the section 4A, section 4 in the Care of Children Act, as well as 5A, because it says that what's supposed to happen is it's not supposed to be the lawyer for child checking with the child to see when we're going to get a report done. 5A comes into play where the guardians must do, the guardians or parents must do that. Okay. But because nobody knows the lawyer for child in there, and the court is running amok on it.
So there's 5A. Is that the one you're talking about?
Section 5.
5? Not
5A. Down to section 5, right? And you'll see in the principles, right? And this is the other thing where it says in the principles 5A, okay, it's got to be the parents that normally deal with those sorts of things, 5A and B. The child's upbringing is primarily the parent's responsibility. It doesn't, and the parents as guardians, it doesn't remove their responsibility of talking to their child like they would for anything and saying they want you to undergo this, do you want to do it? It's not supposed to be lawyer for child and doing that sort of stuff. The other thing, if you look at A, if you look at the fourth word in, a child's safety must be protected. In the judgment, it clearly says, oh, you don't, in that same one there?
In here?
No, in the 5 where you were.
Yeah.
So if you go into this section 5, right, now subsection A there, the fourth word in says must. Right? So A says must, all the other ones note that this says should. It does not say must. Right? So when you've got this is where you've got family that are saying like the fungi situation, where they're saying yes, but the child's relationship, it needs to be strengthened and preserved. It should be strengthened and preserved. However, in the other judges, yes, that it should be strengthened and preserved with the father, in other words, the mother and father and the children, and not so much the wider whānau group. But the judge made a very clear point that 5A is the only one under the principles that says must, the rest say should.
Yeah, and that one there is should with both of his or her parents.
Yes, but the top part there, a child's safety must be protected.
Yeah.
Right? And the rest of it is should. So what the judge said was A and B go together because it's normally the parents that are going to protect the child.
Yep.
So you would say, even though that says should, it's backed up by A. The rest of them is should.
Yeah.
So when it comes to that, and you're looking at those types of situations, that's what you refer to. If someone else has looked after the child, but you're seeking the return of the child, emphasise the fact that mum and dad must make sure the child is safe, mum and dad should have preference over the wider whānau group, and so should the child's siblings.
Yeah, of course, the closer relation.
Yes, but the judges don't do that. This is the thing. So you've got to find a way, if you've got counsel, to get them to emphasise that. Because all of these small things, what I've noticed is they seem tiny, but they have a major effect in the actual case.
Right. And the whole point we're showing this is so people can learn these case laws and put them in as footnotes into their submissions. Because
yes, the idea when you're putting a submission in together, how it's got the family court recordings. If you're trying to get there, grab that particular part and also put the part where it's bold saying family court recordings. Drop that into your submission, put it in as a footnote for the case name down the bottom, and then just find the paragraph that says that part, because you've got them there, and then just put the number of the paragraph next to it in square brackets in the footnote. There is your authority in case law to back up what you're saying.
Yeah. And this you can make a submission till the cows come home and quote as much legislation as you like, but if you don't have the supporting case law, or even make the legislation you're referring to and turn that into a footnote and make that into an authority as well, then it'll have a lot more power, because the authorities have more power than the written legislation.
Because what I've found is that if we attach them as exhibits, as we do in affidavits, if it's a piece of legislation, it's just seen like a statement.
Yeah.
It's not seen as an actual authority that you're relying on. So by putting it into your footnotes at the bottom of the document, when I say bottom document, as you enter
bottom
the
of each page, wherever the footnote's referred to.
Yeah,
Yep.
it ends up at the bottom of the page where you put the footnote, put it in down there, and then what you're doing is the judgments that are there so that you don't have to find the judgment for it. You've got the two documents together in one folder.
Exactly. That's the puppy.
Because it would be, I myself would find it very frustrating if someone had supplied this sort of information, then I've got to go and find that judgment to be able to actually use it.
So not only
it just doesn't make sense.
Not only is there the Word document with the interesting parts and sections and paragraphs that you need, but when you're filing case law, and this is just for anyone who's watching this, when you're filing your submissions and you're putting in authorities, they also like to have the copy of the case law, in this case GS versus the family court. They need that PDF supplied with your submissions.
Yes.
Yeah.
You've got to have the full document.
Which is why the PDF's there.
The paragraph.
Yeah.
Unfortunately, courts don't accept that.
No. But that's all right. If you give them 50 footnotes, then you're giving them 50 fucking different cases they can read through. They will love your ass for that, won't they?
Well, I mean, I supplied 18, so you know.
Yeah, exactly. But the more you can, the more power to it.
Yeah, that's the way I looked at it. Is the more you can put in, the more nails you're driving in that coffin.
That's right. Where are we up to here?
I think we're up to D&E now.
Yep.
That's one I did a while ago, and I honestly can't actually. I know it's a Court of Appeal because I can tell by the Court of Appeal document. Once it's open, I might remember. Habeus Corpus.
Yeah, Habeus Corpus Authority. Come on.
Is it not one day?
Oh, it'll open. It's just when it wants to. There we go.
Right.
All right. And
so what have we got there? Okay, right. So this case here is another one where that was successful in the Habeus Corpus application. What it is, is the Chief Executive of our own community, back in the days of the SIPS Act, tried to state that by producing the 101 or the 78 or the 110 orders, that was conclusive proof that the child was to remain in care. Right? It's not conclusive proof at all, as was stated by the High Court there, Court of Appeal, sorry, because just because you've got the orders there does not mean that you are not detaining the child.
Yeah, the order establishes the lawfulness of the detention of the child and making this submission as chief.
Yes,
Yeah.
but the issue becomes, this is where people will get stuck on this, okay, with habeas corpus. The issue becomes, you're going to go and you're going to argue, my child is in the custody of the chief executive. Wrong argument. Custody does not constitute detainment. It is the guardianship that constitutes the detainment, because guardianship is listed as being controlling the child.
Yeah.
That is where the detainment from. And so that's why you implement Section 22 of the New Zealand Law and Section 18 of the New Zealand Law, as well as the UNICROC Article 3 in the ICCPR. And you can also, just in general, state that it is also covered under the European rights of the child, because we can still use those.
Yeah, the EU declaration and the UN declarations and the ICCPRs, they're all different things.
You'll see in there they quote the Emmanuel versus Rumataka prison. Now, what I'm going to say about that is this. Okay, when you actually, I've read the Emmanuel versus Rumataka prison judgment. I didn't bother putting it in these because it's not to do with the family court.
Emmanuel
But
versus
what they do is they pick the paragraphs that suit the narrative for what they're trying to get across to the court.
Yeah.
Now, from memory, let's see, that's paragraph 34. However, in 47 down further there. Now, the issue is, in Emmanuel versus Rumataka prison, at 44 it stated the opposite to 34.
Oh, what?
Yes. Emmanuel versus Rumataka prison is the one where the 10-year thing was done, and that was the one that tried 3 times in 4 months and succeeded on the 3rd time.
This is the guy that got 33.
By the 3rd time,
this is the guy that did 33 days extra jail.
By the 3rd time he had worked out, in that manual one, by the 3rd time he had worked out that, hello, I shouldn't be arguing custody, I should be arguing detention.
Yeah, or guardianship.
Yeah, detention by way, yeah. Because either way, it doesn't matter where you are. Like if you're in a mental health facility, habeas corpus applies to you. If you're in there, like you know how they get those orders to put them in the mental health units.
Condemned.
Yeah, habeas corpus still applies to that because you're still detained. So anywhere where detention can be established, habeas corpus applies.
Very handy. Minimal intrusion, no FGC held before care and protection application. Oh, that's an interesting point.
Yes, because they must hold an FGC before they apply for a care and protection order. If they don't hold the FGC before they go for the 68, then
there's no agreement that
the orders can't be given. The orders can't be given.
And it's
not whether there's an agreement. It's not whether there's an agreement. What it is was one held. It's a requirement of the OT Act to be able to hold an FGC before trying to apply for a Section 68 care and protection order. If you don't do so, if the social worker doesn't organise that, they don't have the ability to apply for an interim order, because the interim 78 that they're going to apply for is subject to the Section 68 care and protection application being made. And the reason they're given the interim 78 is you can have custody in the interim until we decide is the child in need of care and protection, and then move on to the 101 order.
Yeah, and Section
But the interesting thing to know about that too is, even though the FGC may be held, if they make applications for an order under 68 and 78.1, okay, always turn around and make sure that the 186 report and the 128 plan went in. Even if you were not part of making it, because you've gone, if you've been to the FGC and gone, no, we've got no care and protection concerns, always make sure that you're inquiring as to, has the 68 been put in? Because it's the 68 that's going to establish the care and protection. And what the court can't do is, if you've got someone else that can help you outside of the courtroom and support you in your home, and you've got community supports, then the court doesn't have the ability, because of Section 73, to give them the orders. Because what Section 73 says is that a court can't make an order if there are other mechanisms to make sure that there is care and protection in place for the child. And so that sort of pees them off, because all of a sudden now they can't get the order. If there isn't any other mechanisms in place, what you do is when they give you a copy of the plan, you go through the plan. Now, if the plan says that anything you disagree with, then under 1371D of the Act, you raise issues with the court. The court now has to turn around and take the plan to a hearing, because they've now got a disagreement between the parties. So if one party is saying, no, I disagree, that plan's not adequate or appropriate for my child, then the court can't approve it under 130, because one of the things that the court's got to do is make sure that under section 130, the plan is appropriate and adequate before making any 101 orders. So if there's been a few judgments I've read where the judges have turned away the 128 plans, because in their view, and this is a fair view, okay, if the child is already under an order, 6 months later, if it's a child under the age of 7, a 135 review is due, so they got to file that, and then a 128.
Yeah.
Now, if they're saying that there was issues at the beginning, and the why are we involved part says this is the reasons why we believe we need to be involved, it's only natural that if they manage to gain custody, changes should have occurred for the positive for the child. So if the why are we involved hasn't changed at your next review, if you don't have issues with it as a parent, then in my view you seriously need your head looked at, because you haven't had the child. Yeah, so there's no way that the why are we involved could be the same. There should be some sort of change there, even if it's only a little bit for the positive. Like, for instance, in our case, okay, it's been put forward that the same issues that were there 3 years ago are still there. I'm dumbfounded as to how they think that's possible.
Yeah, that's not. They need to have a little dip their toe into a little sink of reality.
Exactly, yeah. But it's just knowing things like that, where you can then go into a courtroom and go, well, I'm sorry, Your Honour, but I've got issues with the plan, so we've got to take this to a hearing. They're not going to like that, because they can't advance forward and keep the case moving at the pace they want it to, because you've now raised issues that they have to deal with. Otherwise, it's a procedural error and judicial impropriety.
This is finally open.
The last one, number 9, D versus Family Court.
Yep.
That one there, okay, that is like our friend Fifi down south.
All right.
So what happens here? Okay, if you're a parent and it's a care of children case, as it says, grant of leave due to direction of psychological report. If there's been no 133 report in your case, and the judge decides, like, if you're seeking to discharge the orders or have it varied so that you can have more time or get custody of the child, and it's within 2 years of the parenting order being made, they always say to you, you require section 1398 leave, and then a hearing has to be held for it. If you believe something is gone astray and a psychological report should be done on the parent that got the parenting order in their favour, the minute you request a 133 to be done and the judge directs it, that is a material change in circumstances, and your leave must be granted to be heard straight away then. When I say straight away, it'll probably take them about 60 days to hear it, but the important part is, if you've been trying to get leave to get heard, and there's been no updated psychological report, ask for one to be directed. The minute the judge, everyone else will agree, and the minute they agree and the judge directs it, you just state to the court, well, the 139A leave I was required to apply for, I no longer do, because a material change in circumstance happened with that, with the court directing the 133 report.
Yeah.
The other thing, so it's in regards to our friend down south, in this case, because I know whose case this is, when I read her judgment, I was quite surprised. And I was like, okay, so the registry, in this case, refused to accept her filings. Does that ring a bell?
Yeah.
Now, what ended up happening was, she took this up to, I think it was the High Court or the Court of Appeal, and the judge agreed with her. The court registry had no reason not to accept the filings. The judge had no reason to direct that she not be able to file anything through the registry It was a breach of natural justice because everybody's got to be able to access justice, and she didn't have the ability to because the court stopped her filing. Now that also rings a bell in my proceedings, doesn't it?
Yeah, it does. Breach of natural, yeah, registry are problematic.
So it's interesting stuff for people that are like if you're trying to get, you're a self-representative and you're trying to file and the court registry won't let you, and the judges directed that you can no longer file certain things.
Yeah.
There is your case law there that quite clearly says from the higher up courts that by the registry doing this and the judge doing it, there was a breach of that person's natural justice. And so that particular part there of the judgment, down the bottom of the judgment, the order that was put out for her to not be able to file was overturned. So from there on she could file anything she wanted. Which is how it should be.
Yeah, of course.
Because if you can't file even a simple memorandum like us, we've got to fight back on it because of the fact that so what happens to the child if something as bad has happened to the child and you cannot inform them?
Yeah, well, exactly. You must have communication open with the court at all times.
And you'd be amazed how many judges are shutting people down from filing because they believe it's a vexatious proceedings. It's not a vexatious proceedings if you're trying to make sure that your child is okay.
Yeah, exactly.
But they don't see it from that point of view. They just see it from the point of view, oh, bugger off, you're filing too much paperwork.
Yeah, exactly.
That is your right.
We have to.
You need to file to inform the court. That is your right. Otherwise, we don't have access to justice, and then everybody. Okay, I mean, that sounds stupid, doesn't it? Everybody already doesn't trust the justice system. I mean, if you look at the country now, nobody trusts the whole government.
Yeah, they either say it's the just us system or the injustice system.
Yep, or it's one other person put me. They called it the right thing. And what is that? Well, it's just ice because they're cold bastards.
Yeah, exactly. It's got no emotion, that fucking thing.
Yeah.
Creature.
So it's been. I mean, I've still got hundreds of thousands of judgments to read. Because there's heaps and heaps and heaps of them. Yeah. What's that one here?
This is the CLN.
Oh, satisfy the jurisdictional principles. Yes. So. Now, the other thing that people have got to be able to understand, okay, is this, in this case here, the jurisdictional principles, the courts will turn around and tell you this is not the right procedural pathway to follow or the right application to make. No court anywhere has the right to do what they call a jurisdictional bar. And what I mean by that is, if you make an application, like for instance, if you decided to do an appeal, but judicial review or habeas corpus was open to you, the jurisdictional bar means that they're stopping you using the other two, but they don't have the facility to do that because it is your choice which pathway you decide to take. If you decide to take all three, that's your choice too.
Right.
But there's a lot of, what's been going on is there's been a lot of judges in these judgments that are stopping people applying for certain things, and they don't have the ability, and they call it a jurisdictional bar because what we read up as being like the Care of Children Act being legislation, the Orangatamaki Act being legislations, they are jurisdictional, those are the parts that give the jurisdiction, so it's referred to as jurisdictional legislation. And so the jurisdictional bar just means that they're not allowing you to apply under that jurisdictional legislation, and they can't do that.
Just looking at a bit.
So you can see I've been going through a lot of different things there.
Haven't you? Okay.
The issue is when it gets trapped in your brain.
You wake up in the middle of the night, section 46.
Oh, do you know what the bad thing is when you can go to sleep and dream that you're in a courtroom talking about it?
Oh, no. I seriously recommend smoking serious amounts of drugs if that sort of shit happens. Kids, don't do that at home.
It's just a case of, I was looking at it from the point of view, yes, we needed these to be able to help with our case, but in general, they'd be able to help a lot of other whānau out there that don't know where to look for it.
Yeah.
And when you read, I mean, like if you actually read some of that stuff that I've copied and pasted into those documents, it's quite clear that half the people out there wouldn't have an understanding of what it means.
No.
So,
but they're all parts that are needed for your submissions. Your camera's gone again.
I noticed that. I just heard it go.
Might be a voltage thing. Might be a low voltage. Might be a low voltage thing on your USB that's powering the camera or something. Just drop.
Oh, the problem is because I've got it plugged up into my other hub, but then it's one of those things where you buy a hub and then they've got a power cord, but they never supply the power.
No, they never supply the fucking adapter, do they? It's just a stupid little socket that you've got to find the stupidest little pinpoint fucking plug for. Yeah.
Reminds me of the old Nokia phone days.
Yeah, exactly. Nokia plugs were just like that, and the Alcatels.
Yeah, but I just decided to start putting these together into a folder because, yeah, number one, we needed to use them, and number two, I figured, okay, well, like I said, there's people out there that aren't going to know what to look for.
Yeah, well, I can put these into a shared folder, into the legal templates for all folder, and a subfolder there for people if they need to use them, eh?
Oh yeah, no problem at all. That's the whole point of it.
Yeah.
The point of it is to be able to get some knowledge out there, and if you like I said, I've been looking on the judicial decisions on one that you gave me, and the missus just happened to come across the other one, and what I found was better about that one is the fact that each judgment, when it's not done in the PDF form first of all, it's got the case law in there that they're referring to, and you can click on it and go straight to the next case law.
Oh,
whereas
nice.
in the judicial decisions online, in the footnotes, you've got to find them.
Yeah.
So in the NZLI, I think it's NZLII, in there, the ones they're referring to that are already highlighted, so you can get them downloaded.
Yeah.
So that's why I decided, okay, I'll go through and download these, and I'll tell you what, the amount of, it was pretty funny the other day. I was reading the 344 paragraph one, and she goes, found four more. I was like, oh.
Good of her.
But you know, we need as many as we can get, because the more you can shove in their face,
oh, for sure,
the more you can go shove it up you too.
Well, when you call them authorities, you know, who doesn't want more authority than the other person?
Well, yeah, but what I found interesting was when I got the response back from the other document I just sent through, and then the Crown representative couldn't answer the one where I was saying about the guardianship constitutes detention. There's been no answer from any of them in regards to that.
Yeah, well,
so all that tells me is they're not able to answer it.
That's a hot potato for them, mate. No one wants to touch that with a 10-foot barge pole.
Honestly, myself, I wouldn't either.
Yeah.
Because if someone put that in front of me, where am I going to find something that's going to be able to overrule that?
Not when you've got a case law with the chief executive saying that it constitutes detention.
That's right. That makes it really, really, really hard. But it's a I just think it's an interesting concept of the way these have been done. And what I found from reading all of the judgments that I've read so far, here we go again.
Yeah.
What I found is that district court, family court, no matter what, they try and hide as much as they can. Get up to the High Court, the High Courts will a lot of the time back them up. Once it gets to the Court of Appeal, the Court of Appeal sends it back to the High Court and says, do your fucking job.
Yeah. And if the Court of Appeal doesn't want to do their job properly, you have to go all the way up to the fucking Supreme Court to go back down to High Court.
The issue though with Supreme Court, okay, is you can't just apply and get in. You've got to have a real good reason for leave to get in. Yeah. I've read a lot of Supreme Court judgments. I've been through 10 years of them, and every single one of them, except for two over that 10-year period, all of the others did not get leave to come in.
Shit.
So it goes to show you, and how I was always told that, okay, they sit like 4 times a year. No, they don't. They sit every month of the year. It's the registry booking the cases that is once every quarter.
Yeah. So it's
but I couldn't believe it when I come across one particular case where this guy had tried so many times, I think it was like 18 or 19 times over a 2-year period to get leave, that every time he got turned down, it was $2,500 to the respondent, right? And on one of them, if you're going to try taking on the justices of the Supreme Court, give it in a civil litigation in the High Court first. Don't take it to the Supreme Court and try and bring it in there.
Yeah, of course.
But that's what he did. On just on one sitting, it cost him $20,000 because they said leave wasn't granted, and it was $2,500 per justice.
Good God.
So when you go to the Supreme Court, if you're trying to get leave and you can't get the leave, that costs you $2,500 already to the respondent. It's done sort of as a deterrent to getting people to come in.
I was just going to say that. It's just like you can come here, but only if you've got the cash in case you fuck out.
Well, but you don't even get the chance to secure. It's not like security costs, like in the cases we've been dealing with. This is different again. This is asking for leave, and if you fail in getting the leave, you've got to pay the respondent $2,500, and it didn't even get into court.
So you better have rock solid reasoning for asking for leave.
Yeah. Whereas the lady that I was telling you about, I mean, she's the only one I know of that's managed to get leave to get the security costs wiped.
Wow. Oh well.
Yeah, it was just over $150,000, I think it was.
Crazy amounts of money.
It's amazing how the courts will double everything up just to try and stop you bringing a case.
Yeah.
You know, that one started at like $70,000, I think it was, or $47,000, doubled up to 94, doubled up to 184. Just because they could.
Yeah, exactly. Anything to deter us self-representing litigants.
Yeah, well, I think in the end, though, that they're not deterring us because we just keep coming back.
All right, bro.
Yeah, no, it's like I said, it's been an interesting week studying all that stuff, or 2 weeks, and I still ain't finished because I'm going to find more.
Yeah.
Because I can guarantee the justice system's going to try and screw us over again.
I'll try and find some more search links for your wifey to have a look at.
Yeah, I've got to admit they have been interesting reads. I just like seeing it where it says like 37 or 44 pages because that's not very long.
Oh, the paragraphs.
94 or 104 pages. It's like, okay, how many bloody...
Yeah, they put in way too much.
But I've got to admit that GNS one, that had a hell of a lot of it.
Yeah, that's the two lawyers.
Yeah.
Well, that's
it had a hell of a lot of it, and it was good because there was quoted parts in there, or parts the judge had talked about in there, where he'd quoted what the actual father had asked for. So it was good because it got those understandings of being able to go, right, so this is what we've been asking for, he's put it in these terms, this is what we need to ask for to get forward.
Yeah, and it's because they
were... well, I'll leave you to it, you can have a good night.
I
just thought it'd be worth getting it out there that there's some judgments there, people can use them, use the paragraphs of it. I mean, if people don't think that part applies to them, read the rest of the judgment. There's probably something in there that will apply to your case that I haven't brought out of it, simply because I was mainly looking for our case, but as I was reading through, that will help someone else, that will help someone else.
Yeah.
I knew it wouldn't help us because we were past that part, but
yeah, sure. But it's, as you say, it's always the things the day after you've done your submissions, you run into the bit that could have helped.
Well, that was the. I mean, that actually happened to us on the synopsis for Habeus Corpus. We put it in, and then the missus found that S&L one, right? And it's like, so it's like, I know what, quickly erase it and put it in overnight, and then turn around and say, disregard the last one.
Yeah, that's the one. Please do.
And then that's good.
Yeah. All right, bro.
So the next one is to see what happens with Jesse and all of them, because I'm curious what's going to happen with his on Friday.
Yeah, well, they're 2 days overdue, aren't they? If that's the case.
2 days overdue. Well, I mean, they're going to be 2 days overdue, but the fact that what was contained within the filing and supporting documents. So that's like, that made me think straight away, hold on a minute, that's the same stuff I filed. Yes.
Well, looking at that judgment that only came out, what was it, the 16th of September, that Putaru one, 33 days extra in jail, $11,000, that works out at what, $333 a day for every day you're locked up in jail over your time. So if they keep Jesse in there for a few extra days, and Jesse might be able to clock up a bit of extra money coming in his way.
I'll tell you what did crack me up when I was looking through the Supreme Court ones.
Yeah.
Guess who I came across in the judgment that was in the Supreme Court that won against Crown Law and the Attorney General.
Not Families for Justice.
No, but I found him in another judgment again.
Oh no!
Yes. He supported GNS. That's why GNS was having so many problems.
Is that why it reflected badly for a while there?
So the lawyer that was the father in GS,
Yeah.
Families for Justice came up in that.
Causing disturbances in the courts again.
Well, yeah, but it's just reading those sort of things that has been very, very interesting. And yeah, you can take stuff from criminal ones, like in the Supreme Court, the person who won against the government as well as corrections and Attorney General, Arthur Taylor.
Oh, good on him. I see he was just up in Auckland here again. I was seeing on his Facebook he's jumping on the airplane and going back down to Dunedin. So.
Oh, okay, yeah. Because what they were trying to stop, corrections were trying to stop him doing, was being able to stand on his own and represent.
Yeah.
And the Supreme Court said, no, he's allowed to do that.
Yeah. As much as you'd love him not to be a self-represented litigant and not bound by all the rules, tough shit, he is. So,
exactly, yeah.
All right, mate.
Well, I'll let you go and enjoy your night.
Yeah, you too, bro. I'll catch you.
Good. See you later.
See ya.